examination also, that is under challenge. So therefore, there is an urgency in the hearing. Morning they have sought for an
examination is scheduled.
Examinations is already over. The interviews are scheduled, I am told, in the last week of this month. That in this matter.
Your Lordship, in this is a Group 1 notification, Your Lordship. There will be prelims and mains. There will be no interviews. Prelims are conducted, Your Lordship. Mains will be conducted on 21st of this month. The urgency is that, Your Lordship, in prelims also these reservations are applicable. Due to that enhancement from 4% to 10% of the reservation, almost 1,200 members, 1,200 candidates are now entered into main exam, Your Lordship. Now, due to the institutional delay, huge prejudice would be caused to the candidates, Your Lordship. That is the urgency. Again, they'll have to reconduct the main exams, Your Lordship.
I am appearing on behalf of the scheduled tribe people. The GO which has been issued and quantifiable data to enhance the scheduled tribe reservation from 7 to 10%. Where the challenge under the challenge in the repetition in the item 28 has to be examined by the learned single judge according to the writ rules 14A of 1977 of the Andhra Pradesh High Court. But that has been listed before the division bench and obtained the order subject to the outcome of the repetition. And examining the division bench is not valid in the eye of law. Actually, in the certain areas only have to be examined by the division bench.
What is not valid in the eyes of law?
Lordship, sir, the learned single judge has to be examined the repetition because they challenged only GO, not any ultra regulations.
Just a minute. The orders which are under challenge, the documents which are under challenge, whether they have statutory force?
Yes.
Which document? Which document? Whether interim order has a statutory backing?
My lords, the interim GO is violative of the constitution.
Have you decided to avoid our very pertinent and specific question, whether it has any statutory backing?
No, there is no statutory backing.
Then it will go before single bench. We have queries of service matters only when it's a statutory rule, not otherwise, not executive instructions.
Your Lordship, Article 254, Clause 2, that is being violated, Your Lordship. When there is a dispute between
you don't try to understand, it's very difficult to understand, madam. The roster of division bench is only those service matter where constitutional validity of statutory rule is under challenge. If it is executive instruction, it will go before single bench. He is right in taking that objection.
Yes, ma'am. So far as my writ petition,
even an executive instruction may be violative of Article 14, but learned single judge is competent to examine that.
Yes.
Your Lordship, one submission, if I may be permitted. Their incomplete petitioner is Your Lordship, and their incomplete is also not allowed for them to submit.
That will go before the appropriate bench.
Your Lordship, in this matter,
there is no dispute about it that there is no order which has any statutory backing is under challenge.
Yes.
Let it go before single.
May I say one thing, Milits, and we will definitely leave it to your lordships. One submission and I'll leave it. Milits, the matters were listed before different division benches. Plus, after that, the Honorable Chief Justice on administrative side has posted these matters before.
Is there any assignment order?
Yes.
Is there any assignment order by Honorable Chief Justice? Where is that order of Honorable Chief Justice on administrative side?
This item 30 was before DV 1 minutes. Thereafter,
just a challenge?
Yes, me.
Does it have any statutory backing?
Yes, sir. There is no any statutory back, and they didn't challenge any rules as ultra-virus mill. They have challenged only GOMS number, which enhanced from 7 to 10% of scheduled tribe reservation.
This order of Honorable Chief Justice is obtained, is taken by projecting that as if virus is under challenge.
This item 30 minutes was in other items minutes they have mentioned. This my case was there before DB1.
The entire bench is listening parties to their counsel. But during the course of hearing, the learned counsel for the parties jointly and fairly admitted that no order oblique provision which is statutory in nature is called in question in these batch of petitions. Thus, if executive instructions, oblique policy, etc. are called in question, which have no statutory backing, matter may be listed before appropriate single bench.
May I point out one thing?
The registry may verify and list before appropriate single bench expeditiously, but if necessary, order of Honorable Chief Justice may be obtained.
May I under as per Article 15 and 16, plus the state is empowered to provide reservations to the scheduled tribes. That's basing on that article minutes, this GO has been issued. So therefore, minutes the
Article 15 and 16 are not,
15 and 16
are not the orders are not issued under that order.
Yes. Your Lordship, in item number 32, the rule is challenged, Your Lordship.
We were repeatedly asking you when all of you said that.
Your Lordship, I did not want to interfere in this matter. Also, Your Lordship, senior designated is appearing, Your Lordship, in 28.
Item number
28, Your Lordship. But in 32, item number 32, rule is being challenged, Your Lordship.
Which rule is under?
Rule 5.
Please show your relief clause. Please read your relief clause. For reading relief clause, there is a different counsel engaged.
Your Lordship, I am representing for 32, Your Lordship.
Yes, please read the relief clause and tell us which statutory provision is under challenge.
Your Lordship, I apologize, Your Lordship. My senior is held up in admission court, Your Lordship.
Which annexure is under challenge? Which annexure is under challenge? GOMS 33. GOMS 33 has no statutory backing?
yes.
Does it have any statutory backing?
Your Lordship, in item number
GOMS. Let us see that GOMS,
Yes.
whether it is issued under Article 309 or under any statutory
also,
provision.
amendments to the Rule 22 of Telangana State and Subordinate Rule Services 1996. That is being under
Which is that document, madam? Which page number?
I apologize, Your Lordship. I do not have the file because the senior is on legs. As per the
Then
prayer,
on the threshold, you should have prayed for
Let's
password.
see.
I apologize, Your Lordship.
After consuming this much of time and you are saying it is statutory but not in a position to tell us which is that document at which page.
I am also challenging if Your Lordships may kindly take up WP 6844. Your Lordship may take up the GO 33, which is at page 26.
That is same GO.
Same GO.
Page
26 minutes. Your Lordship, may see how this GO is passed. Para 2. After formation of the new state of Telangana in furtherance of the commitment to protect the interest of scheduled
order,
tribes.
it is not issued under
This act, the Scheduled Caste and Scheduled Tribes Special Development Fund Act, was enacted by the state legislature to ensure fund allocation on par with scheduled tribe population. According to the act, the unspent funds in the financial year will not lapse
and will be carried forward to the next year. This special provision has been made for socio-economic upliftment of the scheduled tribes. This measure clearly established the imperative needs for the socio-economic development and for enhancing the reservations for the scheduled tribes in the state. You see the last line of this document. Last line of this document in bold letters. By order in the name of governor. So it is an administrative, it is an executive order or it's a statutory order? It's an executive order, by backing of this act and the article 15 and 16. Those are the reasons for issuing the order, but it's not the statutory backing. Same order. Yes.
I am deeply obliged.
It will go up to 32. 32. Up to 32. Right.
Item number 34, my lordship.
Yes.
My lordship, item number 34, it is coming.